That is the end of your day. You go to doctor, right? You go to doctor. Your doctor said today is the last day for you. Today is the last day. You will jump with joy or jump with cry. Joy. Last day for you, joy. Huh? So you all are jumping. So no classes, nothing happy. If you stop learning, you are literally dead for that day. Assume. If you stop learning, you are dead for that day. Right? Yes. Now, yesterday we have seen mediation. You have to play the different roles. Whenever you are arguing in the lower courts, you have to know civil procedure courts. Whenever you are coming and arguing in the high courts, writ jurisdiction. So whenever you are arguing in the tribunals, principles of natural justice. Whenever you are doing some arbitration cases, arbitration, that means you have to know the rules applicable. You have to play within that arena. ஒரு இதுக்கும் ஒரு rules இருக்கும். High courtல போனா writ rules will be applied. Writ rules will be something different. Civil procedure, civil pleadings will be something different. So here you are a mediator in the sense not an informal mediator, you are a formal mediator. There are different styles or approach while you are doing the mediation on behalf of the clients. Assume that you are a big mediator for a big international companies. So many arbitration conciliation centers are there. It's if you are well versed with these laws, especially UN Central Model laws, you can become an arbitrator for big companies, right? You have to know the law, not only arbitration, general law of the land you have to know. Different styles or approaches are there while you are practicing as a mediator. You can what is called apply these approaches depends upon the facts and circumstances of the case. Right? There are several styles of mediation practiced globally in contemporary area. Different types of what is called styles will be there. Depends upon the case, you can apply that style. They vary according to factors such as parties' goals for the mediation, types of mediator, intervention, and the nature of interface between the parties. Different styles. The parties' objectives in mediation will vary from case to case. For one party, expenditure and time efficient settlement is the prime aim. కొంతమందికి ఏం కావాలి అంటే తొందరగా మా కేసు సాల్వ్ చేయాలి. That depends upon the party's goal. For others who are considering a regular commercial relationship, the need to make calculated and long-term business decisions will be most important criteria. Short term, time efficient. కొంతమందికి ఏం కావాలి అంటే ఈ మీడియేషన్ it is going to affect your entire business mediation. So this should be in the long run. For some people, short run. For some people, long run. Depends upon this. You are applying different styles of mediation will be there. So first one is facilitative mediation. This is one type of mediation. It is the oldest and most prevalent original style of mediation in majority of jurisdiction. Facilitative. You are facilitating the parties to reach a concluded decision within the ambit of the dispute. రైట్. యు మియర్లీ మీడియేటర్ ఏం చేస్తున్నాడంటే ఫెసిలిటేట్ చేస్తాడు. మీ ఇద్దరు కూర్చోబెట్టుకొని దీస్ ఆర్ ద రూల్స్ అప్లికబుల్ ఫార్ యువర్ డిస్ప్యూట్. హీ విల్ బి ప్లేయింగ్ ఏ ఫెసిలిటేటివ్ character. In facilitative mediation, the mediator use a method to help the parties in attainment of a mutually satisfying resolution. No party should be left affected. Both the parties should get mutually inclusive resolution. Right. The mediator, he will raise us the questions, formulate the party's point of view, and also he will formulate certain points of view. This is the what is called gamut of your problem. If you go to civil courts, whenever you are filing the suits, the first stage is framing of issues. Right. Court will frame the issues. మీరు సూట్ ఫైల్ చేసినప్పుడు కోర్టులో ఏం చేస్తారంటే దే ఆర్ గోయింగ్ టు ఫ్రేమ్ ది ఇష్యూస్. ఆన్ దిస్ ఇష్యూస్ ఓన్లీ ద కోర్ట్ ఈస్ గోయింగ్ టు ఆన్సర్. దట్ ఈస్ ద ఫస్ట్ స్టేజ్. మీరు సూట్ ఫైల్ చేసినప్పుడు కోర్టు ఏం చేస్తుందంటే కోర్టు దే విల్ ఫ్రేమ్ సర్టెన్ ఇష్యూస్. హియర్ ఆల్సో ద మీడియేటర్ ఈస్ raising certain issues, point of views. This is the main crux for your dispute settlement. Formulate the parties' point of view and also looks into the possible interest that underside the position taken by the parties. He will see the pros, cons, advantages, disadvantages of both the parties. In mediation, one party should not be affected at the cost of others. Right? One party should not be affected at the cost of others. Unlike in civil courts, everybody's benefit is other person's. One person is getting a benefit, other person is getting what? Detriment. That is the language used by the law. Benefit, detriment. ఎప్పుడు కూడా కోర్టులో ఒక జడ్జిమెంట్ వచ్చింది, ఆర్డర్ వచ్చింది అంటే ఒకతనికి బెనిఫిట్ ఉంటుంది, ఇంకో అతనికి ఏముంటుంది? దట్ ఈస్ లాస్. డెట్రిమెంట్ అంటారు దాన్ని. ఇద్దరికి న్యాయం చేస్తుంది ఆ కోర్టు? చెయ్యదు, ఒకరికే చేస్తుంది. కానీ మీడియేషన్ లో 2% షుడ్ హ్యావ్ ఎన్ అమికబుల్ సొల్యూషన్. Right. Mediator also help the parties in arriving at possible settlement by discussing and analyzing the various options that emerges for settlement of the dispute at hand between the parties. He will observe facilitative style of mediation. Right. He merely facilitates. Here he is restricting himself from making any suggestions to the parties at any time in the course of mediation process or provide the views on the outcome of the dispute. Here, outcome is determined by the parties. He will merely facilitate. ఈ పాయింట్ పైన మీ డిస్ప్యూట్ ఉంది, దిస్ పాయింట్స్ యూ హ్యావ్ టు come to a common understanding, then you can arrive at a common conclusion which should beneficial to both the parties. Facilitate అంటే ఊరికే కూర్చోబెట్టుకొని మీ కేసులో ఇంత బలం ఉంది, మీ కేసులో ఇంత బలం ఉంది, ఇవన్నీ చెప్పిన తర్వాత మీరు ఇలా వెళ్ళారు అంటే then you can arrive at a conclusion. Merely he plays the role of a facilitator. Again, ఊరికే కూర్చోబెట్టుకొని చేసేది కాదు. So many scientific studies will be there. That's why an arbitrator or mediator or conciliator, they have to know the scientific study also. For example, permutations and combinations will be there. Permutations, combinations తెలుసా? విన్నారా ఎప్పుడైనా? Have you heard about permutation combinations? Yes, statistics. దాయం ఉందనుకోండి, 5 సార్లు వేస్తే ఎన్నిసార్లు పడే ఛాన్స్ ఉంటుంది అని స్టడీ ఇస్ దేర్, సైంటిఫిక్ స్టడీస్ దట్ పెర్ముటేషన్ కాంబినేషన్ హీ హ్యాస్ టు నో. ఊరికే కూర్చోబెట్టుకొని జస్ట్ యూ అని చెప్పేసి పంపించేది కాదు. ఇవన్నీ కూడా వీ హ్యావ్ టు ఫాలో దిస్. Chi square test will be there. So many scientific study. You know how the court is going according to the law. Mediators, conciliators are going according to certain scientific aspects, right? So first style is facilitative mediation. He merely plays the roles of a facilitator. He never dictates the outcomes. Simply he will allow the parties to come to a conclusion. Right. In facilitative style of mediation, the mediator is in charge of the process, but the parties are in charge of the result. He can only determine, facilitate the process, but results are determined by the parties. This is one. Second one is evaluative mediation. Second style of mediation is evaluative mediation. Evaluative mediation has similarity with judicial settlement conferences held by the judges. An evaluative mediator, he is guiding the parties in reaching the resolution by highlighting the weakness of their case and predicting what a judge or jury would like to do. ఎవాల్యుయేటివ్ మెడిటేషన్ లో ఏం జరుగుతుంది అంటే, మీ కేసులో చట్టపరంగా ఈ వీక్నెసెస్ అన్నా ఉంది, మీరు దీనికి లోబడే మీరు ఏం చేయాలి, డెసిషన్ తీసుకోవాలి. ఈజ్ ఎవాల్యుయేటింగ్ ద ప్రోస్ అండ్ కాన్స్ ఆఫ్ ది రిజల్ట్స్ ఆఫ్ ది అవుట్కమ్. A mediator adopting the evaluative style of mediation makes formal or informal proposals to the parties as the outcome of the issues. Evaluative mediators are more concerned with your substantive legal rights. You know what is meant by substantive law? What is meant by? Yes, procedural law. You know the difference between substantive law and procedural law. తెలుసా? తెలియమా? ఎన్న substantive law అన్న procedural law అన్న? మౌనిక ఆ మోహన్ చూస్తా, నా మోహన్ చూడ. ఏం సబ్స్టాంటివ్ లా అంటే, ప్రొసీజర్ లా అంటే ఏమి? What is meant by substantive law? What is, you know, different types of laws are there. In your layman language, civil law, criminal law, marriage law, divorce law, that is not the case. Only two types is there. One is substantive, another is procedural law. తెలుసా సబ్స్టాంటివ్ లా అంటే ఏంటనే? మౌనిక తెలుసా? చెప్పు. ఇప్పుడు చెప్తావా, వైవాళ్ళ చెప్తావా? వైవాళ్ళ చెప్తావా? Procedural law is the law which is going to enforce the rights of substantive law. For example, there is a contract between two persons, A and B. Contract is there. If there is a breach of contract, what the other person has to do? If there is a breach of contract, what the other person has to do? Suit. Where suit is to be filed? Where suit is to be filed? Court. End the court. End the court. Lower court anna? What is meant by lower court? civil court. No. That is the mindset of your minds. Straight. That's what I am telling. Everybody is telling court. Lowest court of original civil jurisdiction. Yanda court kana and the court pokodadu. You understand? If you take Indian Contract Act, the law says the parties has to approach the appropriate court of law. That's it. Appropriate court of law. Which court? The law is silent. The law, Indian Contract Act, is silent. Simply it says you approach the appropriate court of law. That's it. ఏ కోర్టు చెప్పలేదు. ఏమి చెప్పకుండా ఉంది అంటే ఏమది? Substantive laws. Now you have to see which court you have to go. Take civil procedure code. It says every suit has to be filed in the lowest court of original civil jurisdiction. Right, lowest court of original civil jurisdiction. For example, IPC is there. Right, in IPC, if you commit a murder, the punishment is 7 years or whatever it may be. Assume that one person has committed an offense of murder. Police will take him to court. Court says go to jail. Is it so? No. Then again, what law you have to take? Criminal procedure code. So here it is there. First FIR has to be filed. FIR quash is there. Charge sheet is filed. Charge sheet quash is there. Proceedings are there. Malli ivanni dentlo untundi. Criminal procedure code lo untundi. We have to know the difference. Simply don't speak courts. You don't know original jurisdiction. You don't know appellate jurisdiction. You don't know revisional jurisdiction. You don't know writ jurisdiction. You don't know epistolary jurisdiction. So many things are there. Now you understand. இப்போ சொல்றாங்களா கோர்ட்னு சொல்லி no, this is how you have to know. அன்னியன் சினிமா தெரியுமா? யார் அன்னியன் சினிமால ஹீரோ? அது கரெக்டா தெரியும். That you know. Dalapati Vijay புது சினிமா என்ன? God, greatest of all time. That you know. You don't know law. You don't know that you know everything. You are purchasing tickets. First day, first show. Right? You are seeing the first your superstar cinema or whatever it may be. ஒரு நாள் விஜய் வீட்டுக்கு போய் வெளில இருந்து விஜயை கூப்பிட்டு ஃபர்ஸ்ட் ஷோ டிக்கெட் பர்ச்சேஸ் பண்ண கொஞ்சம் ஒன்னோட டிஃபன் சாப்பிட்றவான் வருவான் அவன் செக்யூரிட்டி கார்டு போவில்லைன்னு சொல்லுவான். No, you are making him richer and you are becoming a beggar. Right? You are making those persons richer by giving your money. Think of yourself. அதெல்லாம் ஒன்னும் லைஃப்ல வராது. சும்மா ஒரு இட்ஸ் ஓன்லி சம்திங். என்ன உன் பேர் மறந்து போயிட்டான். டைப்ரைட்டிங் இன்ஸ்டிடியூட்டா? ஹனிகிங். தென்னரசு ஹனிகிங். ரைட். Yeah, please. No, lighter side. Everybody is happy. That's what I am telling. If you stop learning, that is the end of your day. At least now onwards, every day learn something new, concepts, new things. Growth is the life. Stagnation is death. మీరు ఎప్పుడు నేర్చుకోవడం మానేస్తున్నారో literally you are dead on that day. Right? We are coming to subjects. Right? So he is telling substantive legal rights of the parties rather than focusing on positions and interests and evaluate based on legal perceptions of fairness. Right based approach, interest based approach is there. Interest based approach. So he is telling your rights, substantive rights under the law. That is evaluative mediation. Third type of mediation is transformative mediation. Right. Transformative mediation is comparatively more recent phenomena of the three. Transformative mediators generally prefers to meet with parties jointly by allowing and supporting the parties in mediation to develop their own resolution basis and also determine the direction of their own process. Transformative mediation. Next style is expert advisory mediation. Expert advisory means you go to an expert, he is advising you. For example, you go to an advocate's office, he will give you an advice. This is the way you have to go. Even it is known as one type of mediation. Expert advisory mediation involves a high intensity of mediators intervention in the problem and adopts principally positional bargaining method. Positional bargaining method. The primary goals of this form of mediation are efficient deliverance of settlements and access to justice. Right. So these goals maintain the pursuance of prompt, legally or technically oriented settlements, which in turn encourages a positional negotiation dialogue and advice giving by the mediators. Right? You are going before senior lawyers. What they are going to do? They are mediating, they are giving expert opinion. Expert advisory mediators are typically senior lawyers or other professionals chosen on the basis of their expertise in the subject matter of a dispute and the pre-eminence rather than the mediation practice skills. Expert advisory mediation. So we have evaluated 3 to 4 styles of mediation. Right. Even mediation is recognized under law also. We are going to see statutory recognition of mediation, conciliation under Indian law. So we are having statutory recognition under Indian law, mediation, conciliation, దీనికన్నిటికీ చట్టబద్ధత ఉంది. These are also having statutory recognition. We are having so many laws out there. Let's go to see the statutory recognition for this mediation or conciliation. First one is Industrial Disputes Act 1947. This is the first law which gives statutory recognition to mediation. Right, right. For the first time, introduced the concept of mediation, conciliation in the Indian context. The conciliators appointed under Section 4 of the Act are charged with duty of mediating in and promoting the settlement of industrial disputes. So whenever industrial dispute arises in a factory under Industrial Disputes Act, conciliators, they step in. So first they will try to console the things. If not possible, they can go before regular proceedings. Complete machinery for conciliation proceedings is provided under the Act. So first chattam edi ante Industrial Disputes Act 1947. That Act is recognizing the conciliators. Second one is Civil Procedure Code, out of court settlement. Right. Any civil dispute can be compromised. Civil disputes అని ఏం చేయొచ్చు? Compromise చేసుకోవచ్చు. Mediation, conciliation could be used. So another act is Family Courts Act 1984 provides for establishment of family courts by state government in consultation with the high courts to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. So under Family Courts Act, there is separate mediation conciliation center is there. So whenever you are filing a petition for divorce in the family court, mandatorily your case will be referred to mediation conciliation. First మీరు డైవర్స్ అప్లై చేయగానే 6 months టైం తర్వాత ఏం చేస్తారు అంటే మీడియేషన్కి వెళ్ళండి అని చెప్తారు. మీడియేషన్కి వెళ్ళిన తర్వాత మీడియేషన్ కన్సీలియేషన్ లో certain persons will be there. They will ask you whether you want to live or you want to separate, right? If that mediation conciliation fails, then only you have to come and approach the again family court. That is mandatory. Whether you like it or not, first your case will be transferred to mediation. First அங்க போகும், அங்க பிடிக்கல, அங்க ஜட்ஜ் கொஸ்டின் கேட்போம், பொண்டாட்டியோட கலந்துருக்கிறியா இல்ல, அப்போ டைவர்ஸ். Then it is a specialized court with a conciliatory approach rather than adversarial approach. நீங்க whenever you are filing a divorce case in the family court, ஜட்ஜி எப்பவுமே ஒன்று சொல்லுவான், என்ன தெரியுமா, கலந்து போங்கன்னு சொல்லுவான். He always says ఎప్పుడు దాకా 3 years 4 years చెప్తానే ఉంటాడు జడ్జి. సార్ మా పొద్దు సార్ అన్న కూడా కలిసిపోండి అంటారు. He will always no I am what is called doing so many cases in family courts. Judge always says కలిసిపోండి ఇద్దరు. సార్ వద్దు సార్ నాకు బోర్ అయిపోయింది, I felt bored with this marriage. No, just have it. He always at maximum he will try you conciliate, right? Last లో ఇస్తాడు, మళ్ళీ ఎప్పుడో ఇస్తాడు 10 ఏళ్ళ తర్వాత. டைவர்ஸ் அப்ளை பண்ணோம், டைவர்ஸ் அப்ளை பண்ணோம், whatever may be the reasons, you don't like the spouse. Divorce case at the age of 30 you applied for divorce, right? Then after 10 years you got a decree, your age is 40. Okay, இப்போ அது next கல்யாணம் பண்ணிக்கலாம்னா first appeal 10 years 50. Okay, again 50 years, okay, no issue. Again appeal Supreme Court, your age is 70. What to do? Your entire life is in divorce only. No, that is the practical things happening in the courts. Without getting a divorce decree, you cannot marry. If you marry, then another crime will be there. Yeah, bigamy, so many things, right? Next one is, yeah, please listen. Yeah, Abhilash, mask, dust allergy, yeah, right? Legal Services Authority Act 1987 made headway by constituting Legal Services Authority, national, state and district level to encourage the settlement of disputes by way of negotiation, mediation and conciliation. First act to Industrial Disputes Act. Industrial Disputes Act lo kuda ADR forms undi. Family court settlements also, again when it is been referred to Legal Services Authority, then award will be passed. Legal Services Authority, different stages you are having legal services. District level Legal Services Authority, state level Legal Services Authority, national level Legal Services Authority. Disputes by way of negotiation, mediation, conciliation. Jamuna, என்ன பண்ற? போன் பாக்குறியா? டைப் அடிக்கிறியா? Right. established lok adalats, permanent lok adalats for pre and post litigation reconciliation of disputes by using mediation conciliatory approach. Right. Next one is Gram Nyayalai Act of 2008 was enacted by the Parliament to establish Gram Nyayalais to function as courts for delivering justice at grassroots levels. This has been not yet notified, but in some states it's a central act. Some states it is functioning. Gram Nyayalai function జరుగుతా ఉంది. Also, introduction of ADR mechanism in the Code of Civil Procedure 1908 is one more radical step taken in recent times by Indian legislature by enacting Section 89 Order 10 Rule 1A, 1B, 1C for providing ADR machinery even in cases pending before the civil courts, and has further authorized the high courts to frame rules for the purpose. The concept of ADR has become an integral part of CPC with the insertion of section 89 different acts. Even under the Negotiable Instruments Act, if any offence has been committed under section 138 and 142, you can go for mediation conciliation. Negotiable Instruments Act, Motor Claims Act, there is mechanism is there. Check bouncing case you can come to Lok Adalat and settle those cases. Check bouncing case Lok Adalat kochi settle cheskovachu. Right? It is emphasized that ADRs can help ease the burden of courts, reduce pendency, and ensure speedy delivery of justice. So we have seen mediation, styles of mediation, respective enactments under the Indian law. There is another concept is there, plea bargaining. Let's we go with plea bargaining. Sometimes it is asked. Next slide. Yes. Till now, we have seen mediation in civil laws. Now there is another, it is there in criminal law also, there is some sort of mediation is there. Criminal cases is also there. In 2000, yeah, please we have to learn this. Criminal cases also. In 2006, a new chapter 21A on plea bargaining was added to the CRPC, which makes it possible for an accused to voluntarily make an application for plea bargaining in certain types of criminal cases. Accused means nor without going for normal trial, certain offences has been come under plea bargaining. Accused can make an application in the court for settlement of his cases. Accused enna pannalaamna court ku poi he can make an application and he can settle the cases. In its most traditional and general sense, plea bargaining refers to pre-trial negotiation. Without going into the trial, accused is making negotiation with the defendant, usually conducted by the counsel and the prosecution. If any accused commits an offense, he will come with the defendant అక్యూజ్డ్ ఏం చేస్తాడు అవతలి వ్యక్తితో ప్లీ బార్గెనింగ్ వచ్చి దే ఆర్ గోయింగ్ టు సెటిల్ ద డిస్ప్యూట్స్ అవుట్ ఆఫ్ ద కోర్ట్స్ డ్యూరింగ్ విచ్ డిఫెండెంట్ అగ్రీస్ టు ప్లీడ్ గిల్టీ ఇన్ ఎక్స్చేంజ్ ఫార్ సర్టైన్ కన్సెషన్స్ బై ది ప్రాసిక్యూటర్. Victim compensation. If you get the victim compensation, if the victim is accepting, then you can settle the certain cases. Plea bargaining. You are bargaining with the defendant. I will give you some amount. Please withdraw my case. He can make an application. The disposition of the criminal charge by agreement between the prosecutor and the accused broadly is called plea bargaining. You understand? Whenever a person is committed an offense, who is filing the case against the accused? State. De facto complainant. De facto complainant. So here what is happened? There is an agreement between whom? State and the accused. Agreement between the state and ఎవరు అంటే పోలీస్ ప్రాసిక్యూటర్స్. నార్మలీ ఒక అఫెన్స్ కమిట్ చేస్తే ఎవరు కేసు ఫైల్ చేస్తారు? స్టేట్. పోలీస్ అండర్ ఆర్టికల్ 12 వీళ్ళు ఏమంటారంటే మీ తరఫున కంప్లైంట్ ఫైల్ చేస్తారు కాబట్టి దే ఆర్ నోన్ యాజ్ de facto complainant. De facto, you are the complainant, they are de facto complainant. An agreement has reached between the prosecutor and accused broadly called plea bargaining. Right. However, unlike most contractual agreements can be enforced by law. Plea bargaining agreements cannot be enforceable by law. ఇక్కడ ఎవరెవరు అగ్రిమెంట్ లోకి ఎంటర్ అవుతున్నారు? ప్రాసిక్యూటర్ అండ్ ది అక్యూజ్డ్. వన్స్ ద ప్రాసిక్యూటర్ ఎంటర్స్ ఇంటూ an agreement, that does not mean that it is enforceable like in contract. However, plea bargaining is applicable to offences other than those. Straight away it is not applicable for all the offences other than those for which the punishment of death. For that offense, no death punishment should be there. For that offense, no imprisonment for life. For that offense, no imprisonment for over 7 years has been provided under the law. You cannot bargain. You cannot take the advantage of plea bargain in an offense. The punishment for that offense is death, imprisonment for life, or imprisonment for more than 7 years. ఈ మూడు కేసులో కూడా ప్లీ బార్గెయినింగ్ అనేది చేయకూడదు. ఇట్ ఈస్ నాట్ అప్లికబుల్. రిమైనింగ్ యూ కెన్ బార్గెయిన్ విత్ ద ప్రాసిక్యూటర్ విత్ ది పర్మిషన్ ఆఫ్ ది డిఫెండెంట్. డిఫెండెంట్ మీన్స్ విక్టిమ్. సో మీరేం చేయొచ్చు అంటే ఈ కేసెస్ లో కాకుండా ఇంత కేసులో ఇల్లాద రిమైనింగ్ కేసెస్ యూ క్యాన్ గో ఆన్ బార్గెయినింగ్ విత్ ది స్టేట్. Also, it does not apply to cases involving socio-economic offences. Socio-economic offences. You know the meaning of socio-economic offences? తెలుసా? తెలియదా? ఎన్న socio-economic offences? స్కామా. కేసీఆర్ కూతురు ఎత్తి లోపల వేసేస్తారు జైల్లో, తిహార్ జైల్లో. ఏమదే? I am asking you the law. Liquor I know the brands also, but I don't drink. Right? Socio-economic offences లో జైలుకి వెళ్తే బెయిల్ రాదు. For example, Prevention of Money Laundering Act. Prevention of Money Laundering కింద once a person has been arrested, you don't get the jail. Manish Sisodia is in jail for 1 year. Our ex-vice chief minister in jail for 18 months. There is different courts will be there. Prevention of money laundering, foreign FEMA, Foreign Exchange Management Act. If you commit any offense, your entire life will be in the jails. these acts are having draconian what is called force. Draconian అంటే వాటి కోరలు ఎక్కువ ఉంటుంది ఈ చట్టానికి. సోషియో ఎకనామిక్ అఫెన్సెస్ సపరేట్ కోడ్స్ ఉంటాయి. యు కమిట్ అన్ అఫెన్స్ అండర్ ప్రివెన్షన్ ఆఫ్ మనీ లాండరింగ్ అండ్ యు కెనాట్ ఆస్క్ ఫర్ ప్లీ బార్గైనింగ్. సోషియో ఎకనామిక్ అఫెన్సెస్ అంటే socio ante which affects the life of the person. So prevention of money laundering, foreign exchange management tax, where enforcement directorates will come, CBI will come. You know the meaning of CBI? Huh? Yeah, Central Bank of, very good, correct. No, he was sleeping, suddenly he woke up and answered the things. సార్ నిద్రపోతున్నాడు, టకామని ఏదో సిబిఎన్పి అంటే సెంట్రల్ బ్యాంక్ ఆఫ్ ఇండియా అన్నాడు. కరెక్టే, ఎలా చెప్పండి, వాని దృష్టిలో అది కరెక్టే. హెన్రీ ఫోర్డ్ సేస్ వన్ థింగ్, ఇఫ్ యు టెల్ yes that is correct, if you tell no that is also correct. If you tell yes you will do it, if you tell no you don't do it, both are correct, he is also correct, right? Correct, you are very good, right. Next one, socio-economic offenses are those that are committed against a woman or a child below 14 years of age. అదేమో చట్టంలో ఏం చట్టం అది? Very good, that also. An accused in a criminal case can request to the court for a plea bargaining by making an application. You can make an application for plea bargaining. Accused చేయొచ్చు. ఎవరి పర్మిషన్ చేయొచ్చు అంటే విక్టిమ్ పర్మిషన్ తో you can enter into an agreement with the state. The application shall consist of a brief. This question is in your question paper. The application shall consist of a brief description of the case, consent of the accused. Accused ఏం చేయాలి? Accept చేయాలి plea bargaining కి. Consent of the accused and an express statement that he understands the nature and extent of the punishment. Right. Here again certain conditions are there. A person who has been previously convicted in a case in which he has been charged with the same offense, he is ineligible under the plea bargaining provision under CRPC to make an application. If you go to the provisions of CPC, CRPC, summary procedure, summary trial is there. Unda, guttunda, summary procedure, summary trial, right? Also, the application must be supported by affidavit of the accused. It is the responsibility of the court to satisfy itself that plea bargaining application has been made voluntarily by the accused. This you have to know. Upon doing so, the court will give the accused and the prosecution complainant the opportunity to arrive at a mutually satisfactory disposition, which will then be recorded by the presiding officer of the court. Once the court delivers a judgment following the plea bargaining process, no appeals are permitted from the same. అంటే అవార్డు ఎలా ఇస్తారో అలా అపీల్ ఉండదు అవార్డులోకి. There is no appeal for award, only you can challenge for setting aside. Here once the judge gives the order for plea bargaining, no appeals are permitted from the same. Right. Where in a case of satisfactory disposition is worked out in the plea conference, the court may award compensation to victim in accordance with the disposition. Plea bargaining recognized under CRPC. The court shall hear the parties on quantum of punishment. Following orders can be made. may release accused on probation of good conduct. The court ఏం చేస్తుంది? రిలీజ్ చేస్తుంది. May release accused after admonition under section 360 CRPC. Admonition అంటే ఏంటి? ఎస్, తిట్టేసి నువ్వు చేయకూడదని చెప్పి పంపించేస్తారు. కోర్టు తిడుతుంది, నువ్వు చేయకూడదు అంటే చెయ్యను సార్ అని చెప్పాలి. చెప్పిన తర్వాత నేనేం చేస్తారో వదిలేస్తారు. అన్ని కేసుల్లో కాదు, లిమిటెడ్ కేసెస్ లో. ఫార్వర్డ్ when you are practicing, you do certain things. I tell the judge that I am going to do the things. Then you tell me your experience. Then afterwards I will tell. Right? Right. అర్థమైందా? నువ్వు కోర్టులో ప్రాక్టీస్ చేసేటప్పుడు జడ్జి మళ్ళీ చేస్తావు అంటే చేస్తానని చెప్పు. చెప్పిన తర్వాత నీకు ఏమైందో చెప్పు. మళ్ళీ నాకు ఫోన్ చేస్తారు ఇట్లా అయిందని చెప్పు. ఐ విల్ కమ్ అండ్ రిలీజ్ యూ ఆన్ బెయిల్. రైట్. For example, contempt of court is there. Contempt of court. Civil contempt is there. Criminal contempt is there. You know Prashant Bhushan, famous senior advocate. Contempt ante rendu untayi. Civil contempt is different, criminal contempt. You have to read the Contempt of Courts Act. It's a wonderful legacy is there. మీరు ఊరికే వెళ్ళేసి కోర్టులో నేను కోర్టు కొనేసుకున్నాను కూర్చున్నాను అంటే ఇట్స్ బెటర్ స్లీప్ ఇన్ ది హౌస్. ఏమన్నా భూషణ, నిద్రపోవడం బెటరు. అండర్స్టాండ్? నౌ యు నో ద మీనింగ్ ఆఫ్ కోర్ట్. தெரியுமா கோர்ட் அண்ணா? என்ன கோர்ட்? வேர் சூட் இஸ் டு பி ஃபைல்ட்? jurisdiction. Where suit is to be filed? Lawyer in the lowest court of original civil jurisdiction. You go to big seminars. Big universities conduct seminars. Every seminar is on only family law. Every seminar is only on contract law. No seminar on company law. No seminar on taxation law. No seminar on insolvency. You know why? The professor, they don't know except those laws. That is, you are going to, no. Whoever comes, seminar on contract law. In Viva also, in which subject you are interested? Family law, sir. Only family law. Only contract law. No other laws, you don't know. Company law is there. If you tell company law, lifting of corporate veil. It's a big lifting of corporate veil. You don't know what is veil, what is corporate. Only you know lifting means lifting. That's it. No. I am not blaming you. I am not blaming you. చదవాలి, చదివితేనే. Ego is good. Ego is good. That means if you become a senior advocate, you are having ego. చుమ్మాలా నాను కరుక్క అంటే వెళ్ళషన్ పోతుండన్నా. ఓన్లీ స్టిక్కర్ లాయర్స్ అంతే. ఏదేమన్నా అన్నం లేదా? స్టిక్కర్ లాయర్స్ అంతే. You go to courts, you face the problem, then you give me a call, say WhatsApp sir, hi, right. May release accused after admonition under section 360 CRPC. Where minimum sentence is provided, the court may award half of the sentence. Where no such minimum punishment is provided, may award 1/4 of the punishment or extendable. So the main aim is to release the accused. Plea bargaining, it's another mechanism to reduce the burden of the courts, right? the judgment pronounced by the court is final and not appealable. Right. But I used to tell in my class, nobody can oust the jurisdiction of the courts under 136, Article 226, 227, divisional jurisdiction. 227. High Court, that's what? Divisional jurisdiction. That means the order passed by the criminal court in plea bargaining is always open to revision under 227. So nobody can oust the jurisdiction of 136, What 136? Huh? Section Article 136 of Supreme Court. Yes. Article 226, 227, it is still there. Appeal is not there. But it is open to revisional jurisdictions. Plea bargaining lo appeal undadu. Kani High Court em cheyochu? It can revise the order passed in the plea bargaining. About no appeal, but different remedies will be there. They will traverse in the different appeal. Yeah, please listen. There is time to sleep. Don't worry. After 3 months, keep CPC under your head and sleep in the home. Time Right. Motor Vehicles Act. So it is known to generate excessive litigation contributing to large pendency of cases. So accidents will be happen as per sections 146 and 149 of the Motor Vehicles Act. Victim compensation in motor accident claim is based on third party insurance. Normally what happens, insurance agencies, they will decline your claim. They will decline your claim. So section 169 of the Act lays down that the tribunal shall follow such summary procedure. Motor accidents vehicle tribunal, they can follow summary procedure as it thinks fit in setting claims of the compensation. So if you go before the tribunal, summary procedure is prescribed under both CRPC, CPC. So within 6 months, they will award the compensation. Next one is Negotiable Instruments Act, NI Act kinda kuda. So one of the proposals that has gained consensus is introduction of ADR in dealing with dishonor of check cases, which includes introducing provision for compulsory reference of dishonor of check cases to any ADR mechanism. Any dispute arising under section 138 of NI Act would be first instance have to be referred to permanent look adolescence. Negotiable instruments kuda akkada refer chestaru. The matter could be taken up before the court only if the parties fail to sign a settlement agreement between the permanent look adolescence. Right? Disputes which are already pending before the courts also may be referred to ADR mechanisms of arbitration, conciliation, mediation, permanent look adalat, everything only by the consent of the parties. Right? So this is what plea bargaining in criminal justice, motor vehicle accident claims, the negotiable instruments. Right. So next is another insolvency and bankruptcy. Insolvency. 7. Right. Now, this is another question which you may get in insolvency and bankruptcy laws, voluntary liquidation of companies. In the previous case, we have seen corporate insolvency resolution process. If it fails, you are going for liquidation order. Here, the company itself is voluntarily going for liquidation. Previously, voluntary liquidation is governed by the Companies Act. Now, voluntary liquidation of a company is now governed by the provisions of Section 59 of the Insolvency and Bankruptcy Code. Voluntary means the company itself is going and filing a liquidation petition. In the previous case, if the resolution plan has not been submitted, if the resolution plan is omitted, the court will order compulsory liquidation. Here, corporate debtor he himself is going before the courts and filing an application for voluntary liquidation. A corporate person will be eligible to opt for voluntary liquidation under the code provided it fulfills the two mandatory conditions. Right. First one, either the company has no debt. Company ఏం ఉండాలి అప్పు ఉండకూడదు. The company should have no debt or that it will be able to pay its debts in full from the proceeds of assets to be sold in the voluntary liquidation. Either the company should have no debts or it is able to pay its debts in full form. Second one is the company is not being liquidated to defraud any person. So these two conditions should be there if any company wants to go for voluntary liquidation. Why? Because if the company is still carrying on the business by making consistent losses, it is bound under the Companies Act and Insolvency Bankruptcy Code to follow the procedures. The reasons for voluntary liquidation: not carrying business operations. Company is not carrying business operations. First. Second one is commercially unviable. It is commercially unviable for the companies to start the business. Third one is company is running into losses. Fourth one, no revenue for the company. Then promoters unable to manage the affairs of the company. Then purpose for which company was formed has been accomplished on contract termination. These are the different reasons by which a company can opt for voluntary liquidation. Now, who may initiate voluntary liquidation proceedings? A corporate person, not a corporate debtor, corporate person who intends to liquidate itself voluntarily and has not committed any default may initiate voluntary liquidation proceedings under the provisions of so and so code. Now, these are the steps involved in voluntary liquidation. First step is you have to submit a declaration to ROC, Register of Companies. The declaration should contain a statement that company will be able to pay its debts as and when it is due and not being liquidated to defraud any person. First మీరు ఏం చేయాలి అంటే registrar of companies will be there. First you have to go before registrar of companies. You have to submit a declaration stating that the company will able to pay its debts. అప్పులు ఉన్నాయంటే మేము తీరుస్తాము. Otherwise, we are not going to liquidate the company, defraud the creditors. అప్పుల వాళ్ళని మోసం చేయడానికి మేము చేయట్లేదు అని చెప్పి you are filing a statement. First you have to go before the registrar of companies, file a statement. Next come to the company, passing of special resolution for approving the proposal of voluntary liquidation and appointment of liquidator within 4 weeks of declaration given to the ROC. So you have to pass a special resolution. Right. If a corporate person owes debts, approval of 2/3 majority creditors would also be required. Right. Next one is public announcement. You know the meaning of public announcement. You are making an announcement in the newspaper that company is going for voluntary liquidation. Why? So many stakeholders will be interested in the company. They have to submit their claims. Public announcement inviting claims of all stakeholders within 5 days of such approval in newspaper as well as on website of the corporate person. Next one is intimation to the ROC and the board. Board means insolvency and bankruptcy board about the approval within 7 days of such approval. Next step is preparation of preliminary report about the capital structure, estimate of assets and liabilities, proposed plan of action, etc., and submission of same to the corporate person within 45 days of such approval. Next one is verification of claims. Whoever has given the claims within 30 days from the last date for receipt of the claims and prepare a list of stakeholders within 45 days from the last date for receipt of claims. Then next one is you have to open bank accounts in the name of the corporate person followed by the words in voluntary liquidation in a scheduled bank for the receipt of all monies due to the corporate person, sale of assets, recovery of monies due to corporate person, realization of uncalled capital. You know the capital structure in the liability side. Uncalled capital will be there. Uncalled capital, if you know the balance sheet. Then unpaid capital contribution. Next one is distribution of the proceeds from realization within 6 months from the receipt of the amount stakeholders, submission of final report by the liquidator to the corporate person, ROC, and the board, and application to NCLT for the dissolution. Right. Again, liquidation is governed by the provisions of IBC. So time limit will be fixed by the NCLT. The main aim of IBC is time bound manner. ప్రతిదానికి టైం ఉంటుంది ఇక్కడ. ప్రతిదానికి టైం ఉంటుంది. Submission of final report by the liquidator to the corporate person, registrar of companies, and the board and application to the National Company Law Tribunal for dissolution. Then once NCLT passes an order of dissolution, submission of NCLT order regarding the dissolution to the concerned ROC within 14 days of receipt of the order. This is what briefly voluntary liquidation of companies. There is one chapter is there, fresh start process. Shall I tell? Fresh start process. Fresh start process. This question has been asked so many times in your paper. Fresh, fresh start. Winding up. Next question. Idika back. 9 పెట్టలేదా? అది 3 పైన 11 అయిపోయింది. ఇప్పుడు ఈ ఏకి తీసుకో. వైండింగ్ పెట్టి చూద్దాం. 10 minutes ఇస్తే ఇట్లా పెట్టేసి పెద్దగా right. Winding up by the tribunal. It is also known as compulsory winding up by the tribunal. Section 271 of the Companies Act before substitution of IBC. Right. If the company has by special resolution resolved that company be wound up by the tribunal. Company has passed a special resolution that it should be wound up by the tribunal. Here, the difference between you yourself is winding up and tribunal is winding up. If you go before the tribunal, there will be a transparency in the procedure. If yourselves go for winding up, sometimes fallacies will be there. If the company has acted against interest of the sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality. If the company's interest goes against all these on an application made by the registrar for this winding up by the tribunal, so many persons will be eligible to file an application. Right. If on an application made by the registrar or any other person authorized by the central government by notification under this act, the tribunal is of the opinion that affairs of the company have been conducted in a fraudulent manner or the company was formed for fraudulent or unlawful purpose or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, misconduct in connection therewith, the tribunal thinks that company would be owned up. Now, even if the company has made a default in filing the financial statements or annual returns for immediately preceding 5 consecutive financial years. So you know every year company has to file financial statements with registrar of companies along with annual returns, cash flow statement, funds flow statement అన్ని ఫైల్ చేయాలి ఆర్ఓసికి. If you don't file it for consecutive 5 years, then the registrar will make an application to the tribunal for winding up of the company. There are certain categories of persons who can make an application to the tribunal for winding up. First one is the company. Second one is contributory or contributories. I told you who contributes to the assets of the company in liquidation. Then the registrar, any person authorized by the central government. Then powers of the tribunal. Once a application has been filed, then it may dismiss it with or without cause, make an interim order, appoint a provisional liquidator of the company till the making of a winding up order, make an order for the winding up of the company with or without cause or any other order, it thinks fit. This is winding up by the tribunal. Yeah, everybody should write the exam very well. All the best for you. Don't clap. No, I don't want your claps. If you write the exam well, that is the gift which you are going to give it to me. Ellarum fail agada final sem pass on. That does not mean that you should fail in fifth sem. Why I am telling you is 2 years will be wasted for you. If you fail in the fifth sem, I will tell you wonderful. Yesterday, I went for correction, university. Constitutional law paper is there. Constitutional law. There is Constitution 1. There is question is there. Uniform civil code. What is the question? What is meant by uniform civil code? என்ன யூனிஃபார்ம் சிவில் கோட் நீங்க போடுற யூனிஃபார்ம் இல்ல யூனிஃபார்ம் சிவில் கோட் என்ன என்ன யூனிஃபார்ம் சிவில் கோட் அண்ணா different marriage acts are there, divorce are there, so and so. They want to bring under same code, civil code, uniform civil code. For example, Hindu is there. If Hindu wants to get married, he has to follow Hindu marriage act. Divorce, Hindu marriage act. Muslim wants to get married, Muslim marriage act, Muslim divorce. Christian, different acts will be there. So government wants to bring a uniform civil code for all the persons. Now I am seeing the paper he has written uniform civil code. Number 1, school uniform. Number 2, NCC uniform. Number 3, military uniform. Number 4, advocate uniform. Number 5, judge uniform. He has written everything. Lastly, sir, please, madam, pass me. That is what uniform civil code is there. I took pity on him. I thought of giving some 20 marks. I put a big 0 for school uniform. But that won't cover under uniform civil code. Right. That is correct. No. If you come in the class, you can take photos. I can't share PPTs. You are taking only PPTs, not professor's photo. That's why they are not allowing you. That's what I am telling you. You are taking only PPTs. You have to take both photos, then only they will allow. You understand? புரிஞ்சுதா? நீ ஒரு PPT மாத்திரம் எடுத்துட்டா அவங்க எப்படி யூஸ் பண்ணுவோம்? I am very lenient. Everybody is taking my PPTs. Only take PPTs, don't my photos. నా ఫోటో తీసుకోబాకండి. You can take PPTs. Right? Throughout this entire class, you got something? You got something with respect to ADR, with respect to insolvency bankruptcy laws, at least something. In place of nothing, something is better than nothing. ஏதாவது இருக்கா மைண்ட்ல? என்ன இருக்கா? வெரி குட். ரைட். யார் சொன்னா தேங்க்யூ? நீ வா, நீ வா. எதுக்கு வா? No, no. Everybody has to do the profession very well. Make a change in your life and make a change in other person's life. நம்ம எப்பவுமே லைஃப் லீட் பண்ண முடியாது. Make a change, remarkable change in the lives of the others. Then only there is a meaning to your life. There is a meaning to your life. You change at least some persons. Not negatively, positively. Negatively, you can change is both negative as well as positive. Don't call your friend for some other things. Call your friend for reading. That is a positive change. Understand? So be the change. Right? All the best for you. Signing off. Yes.